Court is calling 2022 CR 8111, State of Texas versus Michael Teo. Could I have parties announced for the record for the state,
Jason Dorkins for the state.
for the defense?
Andres Campion for the defense.
And are you Mr. Teo?
Yes, Your Honor.
All right. You entered a plea on January 17th to count one. You entered a plea of guilty. The court found there was sufficient evidence to find you guilty. Count two was waived without objection, and so was the enhancement. According to the plea bargain agreement, punishment is to be assessed at 10 years in the prison. Are both parties ready to proceed? State,
Yes, Your Honor.
defense,
Yes, Your Honor.
defense, anything you wish to say on behalf of your client?
We would ask the court to allow Mr. Teo allocution, and then we have one.
All right. You want to raise your right hand? You solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Michael Thayer.
All right, what would you like to say?
To begin with, my condolences, my utmost respect to the family of Mr. Neal. I'm guilty. I failed to render aid. I can replay the incident in my head a million times. I kind of wish I didn't get up, or maybe I drove faster or slower. I'm sorry. I apologize to the family. I'm not a bad person. I just made a bad decision that day, and I understand that I have to take responsibility for my actions. That's it, Your Honor.
All right, thank you.
Your Honor, we would just have argument. The defendant is charged under the failure to stop or render aid statute resulting in death. It is counsel's belief that the legislative intent behind that statute was not particularly to govern a situation that happened in this case. Back on the 1st of July of 2019, this was during the construction that was still going on, that was heavily around the 151 and 410 interchange south of Petrenko. And because of all that construction, the various entrances and exits to the highways were closed, and people were forced to take, instead of a turnaround, to go through a light and come back around. And it was at the intersection where the turnaround was closed that the incident took place. And unfortunately, given the circumstances, this was in the saddest way to express this, an accident. There was no mens rea or mental culpability by Michael involving this, except for leaving the scene and being an individual who failed to stop and give assistance. According to the evidence, and from what I've seen, the first person on the scene, who was an individual behind the decedents, was a woman who had been a nurse for over 20 years, I believe. And she was immediately on scene and was able to provide whatever medical measures were necessary. This was a highly trafficked area, and due to the city statutes and city laws and requirements, there was off-duty law enforcement around the scene because there was construction going on. That's required by the municipal code. And so there were multiple individuals that were immediately there, present around the scene, and that could have administered far superior aid than Mr. Tello could have on the date in question. And I don't believe that there is anything that Michael could have done that would have changed the outcome that happened to, unfortunately, that happened to Mr. Neal. I think that even though Mr. Teo did drive through that intersection, he wasn't the individual that made the contact. His vehicle was struck, and that's not to put blame on Mr. Neal. That is just to show the court that Mr. Teo was not the individual that tried to take the decedent off of the road. He didn't swerve into him. There wasn't any aggressive actions taken by the defendants against the decedent, and that is the only purpose for which that I inform the court or make that type of argument, not to put any blame on the decedent. I know that Mr. Teo is remorseful for his actions. He has reminded me that on multiple times when we've had interactions with each other, and when he's helped me prepare for this case. And I do believe that is the legislative intent behind the statute to govern a situation on a farm to market road or a rural county road or something where there is not high traffic, where the state wants to discourage individuals from leaving the scene and leaving somebody there to bleed out without any shot or of help. However, that wasn't the case surrounding this incident. I don't believe the DA's office thought this was murder or homicide or manslaughter, because none of those charges came down. None of them were presented to a grand jury. And I believe that if the DA's office had believed that to be the case, they would have filed such charges. This is, in the truest form, a terrible, terrible accident. And we understand that everybody here has a duty that needs to be performed, and we ask that the court do nothing over the top other than to follow the agreement. And we would ask that that be done with the understanding that Mr. Teo is remorseful and has pled guilty and understands the gravity of the actions that were taken by him that resulted in the loss of life.
Okay. Anything from the state?
Your Honor, we just asked the court to follow your comment.
All right. Court will find you guilty as previously stated. The court will sentence you to 10 years in the prison, give you credit for any time served. Taking consideration 2019 CR 12685, 2022 CR 5759, and 2022 CR 5760. Is there anything else from either side with regards to sentencing?
Your Honor, we have, I believe, 3 victim impact statements.
All right. Do you have the dismissals, or have those already been tendered?
I think those were previously.
All right. Mr. Teo, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. All right, the next issue is the motion for return of property. My understanding is the state is in agreement that the property be returned to the defendant's father, and it is the 1993 Ford Econoline EF-150. Is that correct?
That's correct, Your Honor.
All right, the court will sign that order. We can go off the record. Mr. Teo, how old are you?
I'm 39, Your Honor.
All right, I see that you're very remorseful. This is what you have to understand. You're not super young. Sometimes people can understand if it's an 18-year-old, 17-year-old, they're not really expert drivers or have been driving long. So maybe it's shock. Let me run home to mom and dad and see what we can fix with this problem. But, you know, the law is the law. If it says you have to stop and render aid, even if that aid is calling somebody and say, hey, there's an accident, this person needs help, you got to do that. You understand?
I understand, Your Honor.
All right. So what's going to happen next is there's going to be victim impact statement. What I can tell you is in this courtroom, I require that everyone to treat everyone with respect. Just listen to what's being said and try to internalize it. Okay.
Okay, Your Honor.
All right. Thank you. All right. State.
Thank you, Your
All right. State, are you, I'm sorry, probation, are you requesting ISF? Because they're saying there are issues with you with alcohol issues. But then I have in the notation from probation that they said that the new misdemeanor case he has, they were going to allow misdemeanor court to handle that.
Yes, Judge, and being that it's a pending case, I advised Mr. Rocha not to talk about it, but we did talk, and I have a synopsis for the court that I can give to you if you're interested.
Okay, yes.
He's I'm not sure if he still is, but at the time he was living in a men's home. He came in from work late, went to McDonald's, and his cell phone went off, which is a violation of their rules. It can't be on at a certain hour. The bunk mate or dorm mate says an employee slash resident took issue with that. They got into a verbal altercation. He was asked to leave, but he is insulin dependent diabetic and he did not have access to his medications if he left immediately. So
All right, just one moment. Probation, if you can come up, and everyone, please whisper.
Your Honor, based on the court summary, they are asking for Bear County ISF. He has completed the bid, the TAP, IOP. He has fees and community service hours remaining. We don't have a current urinalysis on file for him.
All right, Mr. Roach, if you drug tested today, what are the results going to be?
It's probably gonna be positive because I did drink that glass and a half of wine with my meal.
Okay, well, here's the thing. You know you're on probation. How old are you? All right, you're 52. You know you're not supposed to be drinking alcohol. And why are you drinking alcohol when you have insulin issues as well?
I was trying to get some sleep and I got this boil and pain. I did do that, so I realized, you know, it's not that bad.
Everyone, please whisper.
That gave it work.
So your issue for your sleep issues is, oh, wow, let me mix my insulin with alcohol. Nothing can go wrong with this. And it's clear that you have an alcohol problem. And why are you homeless? What's going on?
Became homeless from COVID. I couldn't get back to working at this. I did take care of his mother, she got COVID. And my dad, he's got dementia, so he could. So I had to, I wanted to go COVID care right after that. So I did that with finances and balance. And me and the fiance said we split up. So we negotiated back here.
All right.
So, Joe, I was homeless after that. I was hard to get jobs.
if I may, Judge, we had this very discussion in the back, Your Honor. I advise Mr. Roach to be honest with the court. I feel like honesty is the best policy in this situation. We also discussed that his probation today has included no form of treatment at all to include outpatient treatment. So I think he'd be very willing to try some form of treatment, but I do think that ISF is an escalation of his terms and conditions of probation without trying other things first, Judge, as far as the modality of treatment goes.
Okay. And I'm not the one who placed him on probation, and other judge placed him on probation. Yes.
It does appear that he did complete intensive outpatient treatment.
Whether that was geared towards alcohol or not, Judge.
All right. And I see it was Judge Harlow placed him on probation. All right. This is, are you still at Haven for Hope?
No, I was told I could come back to the courthouse. I did that, we will be back in the trouble.
All right, we're going to go on the record. Court is calling 2019 CR 533, State of Texas versus Mark Anthony Rocha. Could I have parties announced for the record?
Bill Brooks for Mr. Roach, Judge.
All right. And state?
Brittany Mitchell for this.
All right, thank you. And the court received a violation report. Defense, have you had a chance to review the violation report?
I did review the allegations with him, Judge.
All right. So we've had a discussion off the record. Mr. Rocha is testing positive for alcohol, which is a no-no. You're not allowed to drink alcohol while you're on probation at all. It doesn't matter if you're at your house or wherever you may be. Probation, is there anything you wish to add?
Your Honor, he's been compliant and completing his classes, intensive outpatient treatment previously. There are several negative test results on file for him. However, there are also several failure to submit.
And how often is he being asked to submit?
At this point, the last indication he was asked was in February 15, 2023.
All right. And Mr. Rocha, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, off the record, you told the court that you would be positive for alcohol today. All right. Is there anything else you're doing other than alcohol?
Looking for jobs, trying to work as hard as I can.
No, I mean
Oh.
drug issues.
So.
All right, so do not come back to the court because you're using CBD oil or any other products, you understand? So you're not allowed to drink alcohol on probation, you understand? And you understand with the fact that you're taking insulin, that's not a good mixture for you anyway?
Yeah.
All right, so this is what the court is going to do, because we have to address your positive UA. We have to address the fact that you failed to submit UAs. You must submit to UAs in this court, you understand? So I'm going to order 90 meetings in 90 days. And how often did you say you were testing him or he was being tested?
Typically, at this point, Your Honor, it should be monthly. The last requested date was February 15.
You're going to do UAs weekly for 2 months. And we'll see how that goes. Do not miss. If you miss, what's going to end up happening is a motion to revoke is going to be filed. Part of me giving you 2 months weekly, part of it is a punishment because you haven't been testing. The other part of it is I'm trying to help you with your alcohol issues. You understand? And do we have we have the TAP evaluation you said that was done in 2 weeks? I mean, that was done 2 weeks ago or so?
That's it, I think this one is-
Yeah, you said, I think you said 2 weeks.
Apology. I do have to be done, Your Honor.
Okay, so we need to do a new TAP?
Yeah.
All right, I'm gonna order a TAP evaluation. And if the TAP evaluation recommends inpatient treatment, we're gonna start with intensive outpatient treatment. And also do a referral to felony drug court. I know it is offenses, but you all still go on a case-by-case basis.
Yes, Judge.
So we'll do a referral to felony drug court. He is not to be employed as a home healthcare provider or anything with minors. And I'm going to want, you say you're staying at a bunkhouse? Probation, I'm going to want field visits. One time per month until further notice. Probation, is there anything else he needs? Mr. Roach, is there anything else you need from the court?
Judge, he is not back in bunkhouse. Is that the name of it? Yes. He is not back in bunkhouse. He needs to pay for it for.
Yeah, I think it.
All right, so you need to provide the information to probation where you're going to be staying, and that needs to be done no later. Probation, he's going to provide you information where he's staying, and that needs to be done no later than March 23rd. All right, is there anything else you need from the court? Probation, is there anything else he needs?
Your Honor.
All right, thank you, Mr. Rocha. You need to do better.
Thank you very much. Appreciate it.
All right, so I have this here for discovery. Is that correct?
That's correct, Judge.
All right, so what's happening with discovery?
Judge, so it was the blood discovery order. We did receive it back in February.
Mhm.
There was a notice of additional discovery that was uploaded by our paralegal. When I looked in the file today, it wasn't there. I asked her what happened. She said that she couldn't upload it to e-discovery, so she put it back in the file, but it's not there. So I have emailed DPS asking if we can get another copy of it because it was already previously prepared.
So What is it, locked somewhere upstairs?
Judge, I went back up to look in our office. I went to look in the other files that were around this one. As far as I can tell, I don't know where it's at.
All right, so any word on DPS?
No, not yet, Judge. I maybe emailed them about 15 minutes ago. Once we found it, we couldn't find it.
All right, so just wait a moment. We're gonna see if DPS can give us an update today.
Okay,
All right,
can I have just one other discovery issue, Judge?
yes,
Just so the court's aware, the other thing we have going on is the blood retesting in this case.
Mhm.
And so, just so the court has, knows what's going on, Mr. Escobar was real helpful in getting me in touch with the detective at the property room. But the hiccup with him, with that detective is that, he's basically saying, okay, yeah, great, you come and get it. And I mean, I can't go get it. I mean, I need him to send it to the lab or bring it to the lab or something like that. And he's under the impression, he's like, oh no, we have attorneys pick up stuff all the time. And I'm thinking, I think that'd be a terrible idea. So that's why that's a little different, but the order's clear. And the order says he needs to tender it to the lab. So I'm gonna try to take another run at him. but-
all right, state.
Judge, we had connected the defense with the property room. My understanding was that they were supposed to go get it. I don't know what's happening here. This is the first, really, this morning that I've heard about this issue.
Okay, so this is what we're gonna do then. We're recalling this for Thursday. On Thursday, everything needs to be done as far as discovery needs to be handed over to the defense. So state if you have copies of it, bring it down. If it needs to be put on a drive, let's have it put on drive. So March 23rd is the last day we'll have discovery issues. And then if you all can perhaps get with whoever the person is who has this evidence for defense counsel and make sure that issue is worked out.
Okay, Judge.
All right,
March 23rd, Judge.
yes. Ms. Ferguson, on Hitnik is coming back on March 23rd for discovery. All right, I thought Mr. Lee was going to be by Zoom.
We didn't get the Zoom information, so.
All right, whenever I say that they're going to be by Zoom, counsel, you can come and he doesn't have to appear and we'll give you the Zoom link here if need be.
Okay.
All right, so medical records, where are we?
So Judge, we received some medical records. We're trying to figure out. It looks like she may have gone to the hospital twice and we received the second date. We're trying to figure out whether there are records from the day after the offense date, which is what the defense is interested in. So I'm actually drafting an email right now to my investigator to try to clarify whether he confirmed that that was the only hospital visit that the victim had made. It's possible that this hospital, the one that we have the medical records for now, only saw her on this date, and another hospital saw her for the day after the incident. We're just trying to confirm whether those records exist.
All right, counsel, do you know if those records exist for another date?
I do not know. I asked counsel. I don't think counsel was even aware that the medical records that they presented to me was for like a year and 6 months after the incident.
Okay.
In the police report, she stated that she went to go get medical record. She got medical treatment the day after. But she reported to the police officer that proves her case. So it's at the same clinic. I don't know why they didn't ask for those medicals on the day of the alleged incident.
So does the complainant have her own medical records?
She's.
Well, no, I mean, here's the thing, you may want the attorneys to talk.
Mhm.
All right, counsel.
Judge, we talked with her before about getting them. So far, she has not sent them to us. She said that she did receive the treatment. We just don't know if she's actually got the records herself. I think the last communication we had said that she was going to look for them and we didn't get a further update.
All right,
My biggest issue with this case, Judge, is I guess twofold. Number one, my client's been here since the past 2 years. He's trying to get into the military, doesn't have a criminal record. This is holding him up from that. This is a case where they said they have no physical evidence.
all right, so
Weren't made to identify
this
him.
is what we're gonna do. We're recalling this for tomorrow. So say everything needs to be here tomorrow. That,
The
sorry.
medical Records?
Yeah, that's where we are. And are you ready for trial for tomorrow? All right, Ms. Ferguson will give you a reset form for tomorrow, and you need to be here tomorrow at 9. Thanks for dressing appropriately for court. All right, what's happening on this case?
On Mr. McGuffey's case, Judge, we came to an agreement with the states. My client is going to plea on the misdemeanor, and these 2 cases will be dismissed. I've checked, it's County Court 8. Judge Roman is not there. They're all via Zoom. Coordinator for the family violence is not there either. I've gotten their number. I'm also not the attorney of record on the misdemeanor case, but notes have been put into the system. He has a court date on April 18th. He would love to get that sooner. But he's gonna need to get in touch with the public defender's office who's representing him on that case. To see if it can be done this week, next week, something like that, to get it
Who's
knocked
the
out.
attorney with the public defender's office?
I do not know.
It was Rebecca Brett, but she moved law offices, so she's passing it over to somebody else.
All right, we're gonna recall this case for March 23rd. So I'm sure if you talk to Judge Roman and talk to,
Yeah, I have the coordinator's number. I'm gonna try to, even if it's not me handling it, I'll make sure it gets set sooner. He's got an ankle monitor. He wants this done sooner rather than later.
all right, so we're gonna see you back here on March 23rd.
Hopefully not, Judge.
All right, Ms. Ferguson, McAfee, recall for March 23rd. And don't be late again, you understand?
Yes, ma'am. The reason why was because the directions don't be. Yes, ma'am.
Okay, all right, thank you.
Thank you, Judge.
Thank you. Ms. Ferguson will give you a reset form.